Welcome to AT&T's teleconference service. Please enter your access code, followed by the pound sign. We're sorry, your entry is not valid. Please enter your security code, followed by the pound sign. There are 19 participants on the call, including you. You are joining your conference as a participant. For a menu of available commands, press *#.
Getting very good at doing my own tech support from home. Okay, well, I've got 19 people. It does not seem right. So let me just go through. I've got phone numbers here. So let me just go through the phone numbers and see who we got. If I need to start evicting people because we're getting invaders, I can do that. Someone calling in from a 966 number. Let me start with this. Ms. McGovern, what's your phone number that you're dialing?
305-582-4244. Jack, this is Heather. According to your instructions, it's been opened up to the public as well.
Oh, that's correct. Okay, I understand. That's fine. So we may have some members of the public. That's right. I forgot about that. All right, so let's identify the parties to the call. That's Ms. McGovern. Mr. Friedman, what is your dial-in number? You want to just give me the last 4 digits of your phone number, that'll be fine.
I'm calling from a line I don't usually use. I believe it's 9757. Do you see that up there, Judge?
I do see that now, Mr. Friedman. Okay.
That's me.
And Mr. Brenner, do you, last 4 digits of the number you're calling me from?
0160. 0160.
Okay. Okay, so Mr. Freeman, I have Ms. McGovern, I have Mr. Brenner. Ms. McGovern, who's your other team member? If that person could identify themselves in the last
Josiah Wilson.
Mr. Wilson, and Mr. Wilson, if you're on the call, can you just tell me the last 4 digits of your number, please? Mr. Wilson, go on. And twice.
He might have got wrapped into something else. You already indicated he wanted to join, but that's okay. We can go forward.
Great. Okay. So let me turn on before I turn on the recording. And I'm sorry, Miss Kenny. Let me just identify you. I know your number. That's the 244. Right? Okay. So before I turn on the recorder, let me just make sure we understand the procedure here. I'm happy to have the members of the public listening, and I'd ask them all to mute their phone lines and not speak during the hearing. They're just here to listen. That's fine. I have Ms. McGovern, Mr. Brenner, and Mr. Freeman. I can identify you from where I am, and I'll whenever you're ready to speak, you may do so. So I'm going to turn on the recording device now, which will go officially on the record, and then I'll call the case. Your Honor, before you do that, did you do that already? I can, Mr. Brenner.
Yeah, I was just going to say,
This conference is being recorded. Only the main conference is recorded. Conference recording has stopped.
I'm sorry, Judge, I was trying to catch it before. Because I've had a bunch of hearings remotely, and it just is really helpful if Ms. McGovern and I both make sure not to talk while the other one's talking, but sometimes we just to make sure we take extra care not to interrupt each other, because otherwise it gets all always done.
I have the same issue. I tend to interrupt people, and I apologize for that in advance. So yeah, what I'll do is I'll try to, but also for the clarity of the record, I'll try to call on people, and then everyone will get a turn to talk, everyone will get a chance to respond. But I think it is cleaner if we just wait for like public school, you got to wait to be called on. Okay, let me start the recording device now.
This conference is being recorded. Only the main conference is recorded.
Okay, good afternoon, everyone. This is case number 18-80176. Ira Kleiman and WNK Info Resources versus Dr. Craig Wright. Let me start with appearances, please, and I'll start with counsel for the plaintiff.
Good afternoon, Your Honor. This is Val Friedman, counsel for the plaintiff.
Good afternoon, Your Honor. Andrew Brenner, counsel for the plaintiff.
Good afternoon, Mr. Brenner. All right, counsel for the defense, please.
Good afternoon, Your Honor. This is Amanda McGovern, counsel for Dr. Wright. Defense.
Very good. Good afternoon, Ms. McGovern. Okay. As I said before, I understand we have a number of members of the public who are listening in on the call. So again, I will ask you to mute your phones and listen patiently and let lawyers do their thing. So the issue before the court today is that parties wanted to raise two discovery matters. Parties wanted to raise one new discovery matter, and then there was a pending discovery matter from our last hearing. So what I'd like to do is address the pending matter first, and I'll note that since the last hearing, the parties submitted to me in camera materials relating to Mr. Lyman's statement and the origins of that statement, and I have had a chance to review those materials. Ms. McGovern, did you submit everything that you wanted to submit on that issue?
Your Honor, I apologize if this is just my problem, but I caught every other word due to a connection problem. I could certainly try to call back in if it happens again, but I apologize. I did not hear what you said.
Okay, let me just double check. Mr. Brenner, were you able to hear me, or is the issue at my end?
I was able to hear you, Judge.
You were, okay. And Mr. Friedman, were you able to hear me?
I was as well.
Yeah, I think this must be my issue because I can't hear anybody.
Right, Mr. McGovern, why don't you log off and call back in? So I obviously want to make sure that you can hear everything. So I'll wait for you to go ahead and do that.
I'm going to call back in.
That's fine.
Okay, I apologize. I'm sorry. I'm just getting every word. I'm going to call back in right now. Bye-bye.
Hey, Ms. McGovern, are you back?
Hello, Amanda McGovern.
Very good, Ms. McGovern. I have you back there. Let me just... All right, so Ms. McGovern, what I was saying before you were not able to hear me was that I did have a chance to review materials that were submitted on the issue of Mr. Lyman's statement. And I wanted to make sure that you had submitted everything that you wanted to submit on that topic. I received the submission, but I wanted to be sure it was everything that you wanted to submit.
Yes, we have, Your Honor.
Okay, and for Mr. Freeman or Mr. Brenner, have you submitted everything you wanted to submit on the issue of the statement?
Yes, I just want to make sure you're clear on something because there was a little confusion yesterday. The original submission to you in camera inadvertently included us. So when I saw that, I immediately notified Ms. McGovern. She clarified it was an inadvertent disclosure, and I deleted and instructed my team to delete that. So the two, I think there were two, or maybe, I don't know, there was one or two affidavits or statements from Mr. Lynham, but we had not seen those. You got those, which was appropriate. I think you should have gotten. I just want to make sure you understood that because it could have been anything better in email.
No, I appreciate that, and I appreciate your professionalism in that regard, Mr. Brenner. It doesn't surprise me at all. All right. So, Ms. McGovern, would you like to be heard further? And just to make clear on the record, as I understand the issue is as follows. Mr. Kleiman, correct? He's Dr. Wright's uncle. he was deposed, and during the course of his deposition, testified that he had provided a draft of a witness statement to counsel for Dr. Wright in litigation in the United Kingdom. The plaintiffs asked for production of that statement, and the defense's position was that it was work product in the UK litigation, and therefore not subject to disclosure, and I allowed the parties to make whatever evidentiary record they wanted to make. So, assuming I've framed the issue correctly, Ms. McGovern, if I have not, feel free to correct me, but I'll allow you to be heard anything further on that issue.
You are correct, Your Honor.
Okay. Anything further other than what you've already submitted and already argued at the last hearing?
No, Your Honor.
Mr. Friedman or Mr. Brenner, any further arguing from the defense?
Very briefly, and this is Mr. Brenner. By the way, the name is actually, I keep doing what you did, it's L-I-N-A-M, Kleiman, not Lyman. But just a slight correction of your understanding of the factual record. The deposition, there was no testimony whatsoever about it being part of any litigation in the UK. Since the deposition, that is what Ms. McGovern informed me, and I think that's what the affidavit from the British counsel, whose name is escaping me right now, says. So the timeline was that he was dealing with them back in September, British counsel. In January or early this year, they reached out to him again and about a witness statement, and then he testified that he sent Ms. McGovern the witness statement in the early part of the year. I'm not sure, I don't think he said the exact month, in order to try to move these proceedings along, referring to the deposition that we're having. So I think that's the factual record, and I have nothing further to argue other than what I have.
Thank you. All right, so let me roll on that. First of all, let me start by making very clear what I am ruling and what I am not ruling. Okay, I am not making any sort of a ruling as to whether any kind of work product protection applies in the United Kingdom. I do not pretend to know what the law is in the UK as a privilege. But under U.S. law, materials can be work product so long as they are created in anticipation of any litigation. It does not have to be a litigation that we are currently engaged in. So that is my understanding of the theory of Dr. Wright and his counsel in this case, is that this material was created in anticipation of litigation in the UK, and therefore U.S. work product protection would attach to that. So I'm not ruling on UK law issues. I am going to sever, and I'll explain why. I am going to order whoever's making some noise, if you can mute your phone, please. I am going to order disclosure of the statement by Mr. Lynham to counsel for the plaintiffs in this case. It will be subject to the same orders that I have previously imposed, which is that it may only be used in this case, may not be disclosed to anyone who is neither a party nor counsel in this case, and that Dr. Wright and his team may mark it accordingly pursuant to the confidentiality order that is in place in this case. But the basis for my ruling is that having reviewed the materials that were submitted to me, it is clear to me that this statement was not something that was ultimately intended to be kept confidential from the opposing counsel in the UK litigation, and therefore, had it been created as part of U.S. litigation under U.S. law, it would not be work product. And so, for that reason, I'm going to order it disclosed. Again, to be very clear, I am not ordering that counsel for I'm not finding the counsel for Dr. Wright in this case has done anything to waive the privilege that would otherwise have existed. Based on my understanding of the record that has been presented to me, what I am finding is that for U.S. law purposes, no privilege ever attached in the first instance, because it was not intended to remain confidential from opposing counsel. So that'll be my ruling on that. All Ms. McGovern's objections to that ruling are preserved, and Dr. Wright may take whatever appeals he wants to take from that ruling. Let me now turn to the second issue, which has not yet been fully argued, and that is the issue relating to the materials underlying the expert witnesses report. I've had a chance to review the expert witnesses report as well as the submissions by the two parties, And as I understand it, again, to try to frame the issue, it is whether that the doctor who prepared the expert report relied upon work, testing, analysis, evaluation that was done by a colleague, that the colleagues' test results, evaluation, analysis, etc., was provided to Dr. Lim, I forget his name, was provided to the expert who ultimately provided the report in this case, and was relied upon by that author in authoring his expert report. And the plaintiff's position is that, therefore, it is materials that was relied upon by the expert and should become discoverable under Rule 26. And the defense's position is that it is in the essence, the underlying colleagues' materials are in the essence of a draft report or other material that should not be discoverable. So again, I'll turn to Mr. Devlin first.
Well, Your Honor, before you do, I don't want to argue it, but you have not, I think in fairness, you've not actually captured what the plaintiff's position is. So without arguing what the plaintiff's position is, you got part of it, which is the other doctor. We also are entitled to Dr. Kleiman's, and I don't know if I'm pronouncing it right, Dr. Kleiman's notes, and I'll go into this in a little more detail with my argument. So it's Dr. Kleiman's notes, Dr. Sonier's notes, and and I could be a little loose in my language, but I'll call it the psychological assessments that were actually run. So all that's in the report is the final score. We don't have any of the underlying, we don't have the tests that were actually done, which can be hundreds of questions that had to be answered by various folks. So it's not just related to the Dr. Sonier issue, which is part of it, and plaintiff's and defense position is all of that. Everything I just said is a draft report. I think that more accurately frames the issue, and I'll wait to argue.
Thank you, Mr. Brandon. I appreciate that. Let me turn to Ms. McGovern. Well, I guess, Ms. McGovern, I'll treat this in the nature of a motion for particular order, so I'll allow you to go first and last. So I'm happy to hear from you.
I believe actually, Your Honor, raised it correctly. From the defense perspective, the methodology that is used by Dr. Omni Quinn is the same methodology that he uses in every case in which he testifies, and that is that he compiles his assessment, and it is in the form of a draft report with the notes that he takes and the information that he receives. I believe there was a factual statement in the joint discovery memorandum that the underlying, the bulk of the work was in fact performed by colleagues. However, it actually isn't the case. But with respect to this particular argument, the fact of the matter is that, and I think he details this quite well in his report. He has provided under Rule 26A a report which is a complete statement of all the opinions that he's going to express and the basis and the reasons for them. And the draft report is a compilation of all of the observations and the analysis that went into the final report. He does not keep the draft report. He does not do that, not simply in this case, but in any of his work. He is going to be deposed on Tuesday, and the reason for that and the circumstances surrounding that, I'm sure, will be the product of extensive cross-examination. But in terms of the documents that are being sought here, because they are treated, and I'm speaking with after obviously conferring about this issue, because they are treated by the clinician and it is totality of circumstances and opinion by really a leading expert in this field. That's the manner in which he ultimately prepares his final draft, his position, his final report. This isn't, I think, other things sort of, I think, to be noted here is that this is not a cursory report. I mean, it's really extensive, and one of the reasons we wanted to provide any camera was supposed to demonstrate that. But the documents that are being requested by the plaintiffs, this expert does not keep, and he considers them to be drafts.
Well, let me ask you this, because it seemed to me that Mr. Brenner was really breaking the world down into what I would call three categories. One was the underlying raw data, not my terminology, right? The actual answers to assessment questions, things of that nature. That was number one. Number two would have been, and again, I can't pronounce her name, but the non-reporting experts' notes, evaluation, and maybe interim conclusions based upon the raw data, and then ultimately the reporting experts' additional, and again, I use this word not in the technical legal sense, work product during the preparation of the final report. Do you make any distinction among those three categories?
I do believe that those are the documents that are being requested, but the manner in which that data is received and evaluated and reported on or worked on, I don't believe necessarily can be divided into those categories. But again, I think this is the subject of examination of the expert and the manner in which he performs his both methodology and ultimate analysis. It's my understanding, and I'm not an expert in this, obviously, and but it's my understanding that this is not an assessment that really can be broken down into those parts. It is a totality, such that what is not included ultimately in the final report, because it was considered a draft report, is it doesn't become part of it. But so, in other words, assuming, for example, if the assumption is that Dr. Sautier's analysis is going to be separate and apart from Dr. Quinn's analysis, I'm not sure that that's true because they work collaboratively. Similarly, with respect to the questionnaires that are referred to, and I'm sure there'll be extensive questions with respect to that, the manner in which a clinician receives that information and incorporates that into the draft, I'm not sure that they're completely separate. But what I do believe is the case here is that the information that was received in the evaluation and in the assessment all went into what became ultimately a draft report.
I understand. All right, let me hear from Mr. Brenner, and then I'll come back to you for final comments, Mr. Brenner.
Thank you, Judge.
Hold on just one second, Mr. Brenner. I'm sure I interrupt you. I have found the capability. What I'm going to do is I'm going to mute everybody on the call, and then I will unmute just Mr. Brenner, Mr. Friedman, and Ms. McGovern, because I've been getting a lot of background noise, and we have a lot of people to manage on this call. So, pardon me 1 second. Let me do that logistical feat. Hold on.
All participants are now in listen-only mode.
Okay, if I've now done this correctly, Mr. Brenner, you should be able to speak. Why don't you just say something?
Yes, Your Honor.
Okay, I can hear you. Mr. Friedman?
Yes, Your Honor.
And Ms. McGovern?
Yes, Your Honor.
Perfect. Okay, now and the members of the public are muted. Very well. Let me then, Mr. Brenner, I'll allow you to continue. Sorry to interrupt you.
No worries. So I think it's worth stepping back a little bit and looking at what is really going on here and to understand sort of how, frankly, pretty shocking the position that's being taken by the defendant here. at the end of my remarks, I will walk through you the law we cited. Every one of these arguments has been specifically rejected in the courts. Okay. But let's talk about what's going on here. On April 10th, the expert disclosure deadline, the defendant undoubtedly injected a new and rather novel argument into the case. And without getting into the details of the confidentiality of the report, essentially they've hired a clinician, a clinical psychologist, I believe is his actual title, to opine on how courts and fact finders should understand and accept testimony of Dr. Wright. And so what did he do to get there? Well, it's in his report. He reviewed two sets of material and then created one other set of material. So first set of material, what I call the core materials, he reviewed a videotape of Dr. Wright's deposition from last year, I believe the April deposition, 2019. And he read the testimony from a hearing before Your Honor, although it was unclear to me whether it was the deposition that was in the morning of that day or the evidentiary hearing testimony that afternoon. It could have been both. So put aside, I obviously have that stuff. It's not part of what we're doing here today. The entire diagnosis and opinions he's reached were based on what I'm about to tell you today. There are no other factual basis for his opinion other than Dr. Kleiman himself interviewed, apparently it was by video conference, Dr. Wright. And his colleague then did interviews with Dr. Wright's wife, Ramona, his uncle, Donald Kleiman, who we just talked about earlier in the hearing, a sister, and am I blanking out on one? Wife, sister, uncle, mother, and mother. Thank you. So that is, so if we can start with the principle that Rule 26, and Ms. McGovern said she said that the doctor has to disclose his opinions, which I agree he has, and it's not before you today whether those opinions are relevant or admissible in court. That's not before you. And the basis for his opinions. Well, the only basis he revealed for his opinions is, I and my colleague talked to these people, but you're not allowed to you have to take my word for what they told you, what they told me. So I consider myself a pretty decent cross-examiner, but I don't know how you cross-examine that. I don't know how you say, Dr. Quinn, you said that Dr. Wright, and I don't want to get into the report, I don't want to get to individual facts, but you said Dr. Wright said this, and you took notes of that, didn't you, sir? Yes, I did. Can I see them? No, you can't. Well, how do I know he said that to you? You have to take my word for it, sir. So that's how the deposition is going to go. And so I think we can start with the basis that there's no doubt you have the right to test the basis of an expert's opinion. He can't just say, I had tens of hours of interviews and I'm just going to tell you what they said. That's just not what Rule 26 requires. The other thing they did is they ran these assessments. These are written assessments, Judge. They exist. In fact, the whole consultation period took place last week, April 3rd to April 10th. I know that because that's the report says. By April 12th, I requested all this. So the doctor took the assessment. So Ramona Eng, for example, Ramona Watts, filled out, and I can represent the court, it is a lengthy questionnaire with a bunch of questions. She's got to answer all of them. Is it the defense position that she fills it in, the doctor scores it, and then destroys it? And you can't see it? You can't check how the doctor interpreted the data that he was given? How in the world can that be, Judge? So that's sort of the backdrop we're on here. So I don't have the tests. I don't have the notes. So all I can do to say to the doctor is, did he tell you that? And he says, yes, and I move on. Okay, that is not testing the basis of an expert opinion. Now, I think on its face, the argument should be over on that, but this idea that it's a draft report has been specifically rejected by the courts. First of all, you should start with the advisory committee note. The advisory committee note says what the draft report exception is for. The draft report, and I'm talking about the advisory committee wrote to Rule 26. It is specifically for, and Judge, you and I are of a similar age and practice in similar environments. As you recall, there used to be this dance we had to go through because we weren't allowed to communicate with our experts because it was all discoverable. And finally, the court said, wait a second. That's, lawyers are making side agreements to not do that because it's just not practical. You need to be able to communicate with your expert. You communicate often by going back and forth and reviewing reports and revising reports and making suggestions. So the draft report exception, as the advisory committee note makes clear, was specifically to protect against that. Specifically to protect so you don't have to reveal the work product and mental impressions of the attorneys, which often go into draft reports, which ultimately, of course, the expert is responsible to and signs his or her name to. It has nothing to do with the expert's factual data that he or she relied upon. Okay, so this whole idea that it's a draft report, how the assessments can be a draft report, that's not been articulated even in written or comments from Mr. Governor. But you have to understand, Judge, the notes are the factual material that he relied on. Now, what did he do? Just you picked up on the Dr. Saunier issue, and I'm reluctant to harp too much on it, Judge, because I think it's just only the most extreme example of what's happening. Okay, because I think they are no doubt subject to production. But I don't want you to think that I think they're any less subject to than Dr. Kleiman. Dr. Kleiman only interviewed Dr. Wright. The rest were done by Dr. Saunier. So here's what they did, Judge. They each had interviews, apparently at least some were by video. I don't know how many. But let's assume all. It doesn't matter. I accept Mr. Governor's representation that they were not recorded. So Dr. Kleiman is watching his video with Dr. Wright, and Dr. Saunier is watching her video chats or Zooms with the other four witnesses. And they're each taking notes. They both tell you that. Dr. Saunier's notes are referred to in page 2 of the expert report. And in the joint discovery memorandum, counsel for Dr. Wright acknowledges that Dr. Kleiman himself was taking notes. Of course they were, Judge. This is the only basis of what they're basing their opinion on. And then they got in a room and they exchanged notes and they discussed them. So the idea that Dr. Saunier's notes were somehow a draft of Dr. Kleiman's report doesn't make any sense on its face. But that is the body of material that Dr. Kleiman had when he issued his report. He had his notes. He had Dr. Saunier ran 2 of the assessments. He had the assessments. He had her rating. They call them rating scales. He had her rating scales on the assessments. He had his own assessments. And then he put everything together and he penned his final report. But I literally have nothing other than you have all the materials I have, Judge, as to what he used to reach this conclusion. Because you too at least have access to the court record, and perhaps you don't have Dr. Wright's deposition, but that's a court issue. So I told you that the advisory committee note specifically tells us the carving out of the draft reports has nothing to do with protecting the experts' mental impressions or the experts' thoughts or the experts' testing. And, I don't know if you have it in front of you, but the advisory committee says, for example, the experts' testing material involved in litigation and notes of any such testing would not be exempted from discovery by this rule. Similarly, inquiry communications by the expert have with anyone else other than the party's counsel about the opinions expressed is affected by the rule. The rule is meant to protect conversations and communications between counsel and Dr. Kleiman, and I'm assuming, because it's not raised anywhere and they have not said it, the counsel was not on these calls with the various witnesses, but even if they were, it wouldn't sanitize them, only the extent perhaps to not what the lawyers said. And I told you, Judge, this has all been dealt with. This is all the law's already dealt with this. As you can imagine, lawyers have sought in the past to expand the draft report exception, swallow the rule that you have to reveal reliance materials. We cited you on the Wank case. I think it's just worth taking a look at it briefly. Wank is site is 2014 Westlaw 1121920, Wank v. O'Reilly, and that is a case where the expert had materials and the other side wanted them, and the defense lawyers can't have them because they are work product. And again, the court cites to the advisory committee rule and basically says One example of the breadth of discovery still permitted in this discovery of experts, the advisory committee cited the experts test the material involved in litigation in the notes of any such testing. The Wayne Court goes on and discusses on page 3, apart from shielding attorney work product from disclosure, which there is no work product claim here, there's no reason to prevent an opposing party from finding out how an expert arrived at his or her conclusions, including discovering the thought process which led the expert there. Drafts, referring to draft reports, are protected because, as noted above, the drafting process ordinarily entails communications between the expert and counsel. It usually involves feedback from counsel, a process which is likely to include revelation of attorney work product. Notes made independently by an expert, which is where we are here, do not fall into that category. And notes which contain observations about facts or analysis of facts have, quote, factual ingredients, end quote, making them subject to disclosure or discovery. And the court says that you can send it to me in camera, but from what's been described, you're no notes, essentially. And that's on page 3 of the Wayne opinion. As I said, Judge, the only case cited to you by the defendant was a case that says draft reports are not discoverable. I agree with draft reports are not discoverable. I never asked for a draft report of Dr. Klein. The idea that tests are not discoverable, psychological tests, has been dealt with specifically in the Purcell and the Frazier case. Both cases, not surprisingly, deal with psychological testing, and both cases emphatically hold that that is not a draft report. That is the data the experts rely upon, and those need to be produced. Purcell, the citation is 2016 Westlaw 642-7883. Again, it has to do specifically with the psychological test, saying that they are subject to disclosure, and the same for the Frazier case. The site on the Frazier case is 2010 Westlaw 447785. The last thing I wanted to touch on was the Saulnier aspect of it. Remember that 5 of the 6 or 4 of the 5 interviews are not even done by Dr. Klein. They're done by Dr. Saulnier. And they get together and they do what's called a clinician's best diagnosis. I assume that's a term of art or sort of a consensus diagnosis. But yet, we don't even know what Dr. Saulnier put in her notes that Dr. Klein reviewed, because they claimed Dr. Saulnier's notes are Dr. Klein's draft report. And that's dealt with not exactly in this, but in the Penn case that I get you to cite, Your Honor. It's also cited in our brief. These have all been cited in our brief. The Penn environment case, which is 2014 Westlaw 125-89147. And it says there's a wide consensus that notes of experts or communications between experts, expert staff, or other non-attorneys will not be protected from discovery, quote, as draft reports, end quote. And it cites the Ecuador case was a case you'll see in this if you do the research that says holding a list outlining notes, letters, and memos prepared by experts concerning draft report must be produced for actual testing. It's not a draft report. It's literally the entire body of information the expert relied on, all this stuff, other than the deposition and the court proceeding. And I have none of it. I had literally zero of it. And I just, I'll close by saying this issue has been simply addressed and rejected by the courts. If this were the case, think about this for a second. If this were the case, that experts can just gather data, the factual data they rely on, and then say, I put it in my report, so therefore it became a draft report. Think of what that does to the ability to test the opinions. And one thing I do want to guard against is, I suspect, and you may be part of this going to recently, you've said this before in certain situations, or, Mr. Brenner or Mr. Mendoza, I think we've both been on the side of this question for you, which is essentially, what do you want me to do? They've already told you they don't exist, right? And I think we've both had that question for you. And here's the problem, Judge. If they don't exist, but you rule it doesn't matter because they didn't have to produce them, then he's given carte blanche to just destroy them. There's nothing I can do about it. I can't do anything about it. What I need, Your Honor, to rule is that these are not draft reports and they're subject to production. When I depose Dr. Klein next week, if he tells me they're all destroyed, I did the report on Friday, by Sunday everything was in the garbage, that'll be an issue that we'll raise either with you or with Judge Bloom, leave it to trial. But all that's before you today is, are these things, Dr. Klein's notes, Dr. Saulnier's notes, and the actual psychological assessment run. Are these things draft expert reports as contemplated by Rule 26? And the answer to that is unequivocally they are not.
Thank you, Mr. Berman. Mr. Berman, I'm asking a question. It's not that. It's a related question. Not that one. Okay. I'm looking at Rule 26 right now, and I guess what I'm trying to discern is, are you objecting that the report that was provided to you does not conform to the rule because it doesn't adequately identify both facts or data that the parties provided and the expert consumer? I'm the wrong one here, sorry. Right quote, wrong part of the rule. The rule requires, with regard to experts, I guess that's my question. Is your objection, here we go, that the expert's report does not adequately describe facts or data considered by the witness informing his opinions? That's
yes.
That's a different question from they haven't given me some discovery that I want, right? Because the report would simply, the doctor just says, I reached a conclusion, I'm not going to tell you how, and I'm not going to do what I relied upon. That's an inadequate report. I can order them to give you a new report, and whether the underlying documents exist or don't exist, they have to provide you with a new report, and the doctor just has to do his best to remember what he relied upon, and then you can challenge him on that. That's a different question from, I think your report's fine. They told me the facts or data that he relied upon. I just want to see those facts and data so I can challenge them. So I'm just trying to clarify where you are on that.
No, I think it's a little bit of a distinction about our business, but let me be in a careful order and let me try to answer the actual question you're asking. So I believe, and Mr. Governor, I think will agree with me on this, that the way Rule 26 is enforced. So, for example, and we've had this in this case recently, we have it in the case with our expert reports, shows expert reports. I produce an expert report, and it says, my expert says I relied on this, and this. And three of those things are things that everyone has, and three of those things the other party doesn't have. There's no question the practice and rule requires you give them the other three things. Because just to be able to say, I relied on this, but you can't have it, is not what the rule contemplates. So for example, every part of that rule tells you what you need to disclose to their side. And just disclosing that category, like I relied on interviews with the plaintiff or defendant, is not sufficient under the rule. There's no way to test that. So for example, and Your Honor may recall this, happens all the time. Someone says, I relied on deposition testimony, but they've taken notes in the margin of the deposition. Totally producible. No one would dispute that. Because I don't have your notes. You're the opposite. I don't have the notes. You have to give me those. And I don't think that's what's in dispute here. I don't think that the defendant's position is, we just have to tell you what it is, and the fact that you can't get it is your problem. That's not what the rule requires. The rule requires that you disclose them, not just what they are, but actually give them if the other side doesn't already have them. I just think that's the practice. If Your Honor wants, I don't think that's in dispute, but if Your Honor wants me to brief that issue in particular, I'm happy to. But all those cases you'll see are about not just saying, for example, the cases I read you about the psychological test. It's not just saying, I relied on a psychological test I ran. The courts say, no, you have to turn over the test. So I think you're reading the rule, perhaps if I'm reading correctly, maybe a little literal. I don't think it's in dispute that. I think the only thing that's claiming is it's a staff report. That's what we have to get.
No,
so I hope I answered the question.
You did, but I think we're maybe talking past each other. My point, and I will allow Ms. McGovern to be fully heard on all of these issues, but my point was more, you had brought up the issue of, my question about what do you want me to do about it? And in reading the rule, it occurred to me there were two things I could do about it depending on what you're complaining about. If you're complaining that the report itself, on its face, on its four corners, does not contain sufficient information and does not conform to what's required under the rules of evidence in Rule 26, then I would order a revised and amended report that is more detailed. That's not exclusive of the other. There is an alternative or alternative and possibly cumulative, the supplemental. They can run together. Concurrent. There we go. That's sort of concurrent. Concurrent remedy as well, which would be give them the underlying data to justify what's in the report. And I was inquiring whether you think the report's good enough and I'm only dealing with number two, or am I dealing with both of those questions?
No, I think you're dealing with both, and the only thing I want to clarify is when you say the four corners of the report, the problem is there's no backup to the report, right? It's not the four corners. It would be fine. The report would be fine, putting aside the relevance and the materiality and delicate issues with the whole opinion. So put that aside. It would be on the grounds where they can attach. For example, they could have had to attach the notes. The notes of Dr. Kleiman and the assessment. So when you say four corners, if you're including in that in the exhibits, the four corners are in and of themselves sufficient. And what I'm asking you to do is overrule the only objection they made, which is the stuff to draft reports. Okay. And by doing that, you'd be compelling them to turn them over. And their answer may be, I don't have them, and we'll I don't deal with it the way they got to deal with it. But what I don't want is.
Thank you.
Yep.
No, I understand. You finish your sentence. I didn't interrupt you.
No, I'm done. No, I'm done, Judge.
That's okay. All right. I understand your position. Appreciate you clarifying. Let me turn back to you, Governor.
Good afternoon, Your Honor. I do want to step back for a second to just address a couple points that Mr. Brunner made in the beginning of his argument. I think sometimes what happens is you get so far down in the argument that you don't think the first thing said are relevant. That's happened to me in the past. I don't want that to happen again here. This is not a new and novel position. This was not enough time when disclosed expert. This is a critical issue in our case. Dr. Quinn, the former director of the Yale Center of Excellence for Autism, and his colleague, Dr. Sommier, also was former with Yale and now, both considered preeminent clinicians in this regard, will make perfectly clear I am confident in their deposition or in his deposition they would never risk the reputation, particularly in this area, for an expert report in litigation. This was a report that was done because it is an issue in our case, and I think we all know that. I'll add, there were 3 experts added by plaintiffs in this litigation, disclosed for the first time on very novel theories, including if I say blue once, I mean blue the next time I say it. There are, linguists, there are supposed statisticians that we are rebutting today. So I wanted to make that point clear. In addition, with respect to the report, this is a lengthy report, very detailed. It's 17 pages long. The notes on methodology alone are a couple pages long. There are references, as you would expect from a doctor of this, reputation and experience and education, to every single thing that was considered in rendering his conclusion. I don't think it is fair to blend the rule that was discussed just at the very end of the argument under Rule 26. I don't think it's a fair statement that this is not a report that meets the standard of Rule 26A if it doesn't have attached to it the analysis, the notes that were taken during the assessment itself. The report in and of itself is is a report that certainly meets the standards of Rule 26A. So, and I think that's an important distinction here before we get to the underlying question of this expert's sort of the validity and of the report itself, if in fact he doesn't keep grasp of the assessment as it's being made. He specifically states with respect to the methodology that's in the final report, it's a final report based upon the totality of the circumstances, and therefore that's what he considers to be addressed, but I'm certainly not going to speak for him. Vigorous cross-examination, presentation of contrary evidence, and instructions as to the burden of proof of traditional and appropriate means of attacking any kind of admissible evidence. And I'm sure Mr. Brenner will do that. But that doesn't mean that the report was not a, quote, complete statement of all opinions the witness will express and the basis and reasons for them, and the facts or data considered by the witness in performing them. And that's right in Federal Rule of Civil Procedure 26A2. This is the situation in which we find ourselves on this report. And I think that, you know, we all have very tight timelines on this case, and I think that it is helpful and has been instructive that we simply state where we are on certain things. And in this particular situation, Dr. Clint did not keep the notes and the assessment that were taken in forming his final report. He put them into his final report, and he did not keep the drafts, which he refers to as drafts. They didn't document which a draft. That's the way he operates. It's not just for this case. I'm sure Dr. Brenner will make that. Mr. Brenner will make that clear. On Tuesday, this is not a methodology and a situation that was implemented simply because this is this case. It's simply the way this clinician formulates his opinions and ultimately renders a final report on it. And I will also state that with respect to this report, the ultimate conclusions that are made and the bases for those conclusions are very specifically outlined in the report. And all of those bases can be thoroughly examined. I don't understand the connection between taking this expert who, and I'm not trying to get into Dalbert-related things, but there was sort of Dalbert-like tone in the argument that was being made here. And that's for another day. But I do not believe that this expert, when asked about all of the methodologies, is not going to fully answer them. But to suggest that the report, if he states under oath in the position that he holds and the lifelong sort of passion with respect to atypicality, which is extremely sensitive, it's asked, how do I know the mother actually said that? Well, it's evidence if the expert says, or because she told me that. And it's evidence if the expert states, this is what Dr. Wright responded in connection with these questions. And that's important under this particular assessment and evaluation in my field for this reason. What is the difference between that and, well, I want to see the note that demonstrates he actually said it? It certainly wouldn't have been something that would have gone into a report, it seems to me, if, in fact, it's not true. But again, that would go to the weight of it. If Mr. Brenner is going to be able to attack, it seems to me, his methodology, if he doesn't believe it's appropriate or that it was done properly, if in fact his draft report wasn't kept, and I'm sure he'll explore why that is. But we're not in a situation here where this expert's words should be thoroughly discounted, including the methodology employed on a report that he's provided of this, with this detail. And there's I don't believe there can be any claim that Mr. Brenner is not on notice of exactly what the opinions are and exactly what the basis for the conclusions are. So we do have a situation, Your Honor, and I don't want to come back later and discuss this as though it should have been raised before and therefore there's a delay or there's a confusion or there's anything. But I believe we will see at the deposition of Dr. Klin on Tuesday exactly how he goes about performing his final report and how he determines what he includes and what he doesn't, and what he does with those, with what he refers to as sort of a living draft as he is forming his analysis. I believe we'll see that from the expert. But I do not believe that Dr. Klin has those notes to produce at a later time.
Yeah, but what about, I hear you on that, what about the notes or the work product, again, I'm using a legal term, just using it as a generic term.
Sure.
Product of the other doctor and the underlying test results. Again, I don't know everything that was done, but there was some testing administered, and there would be results of those tests, and then there was the first doctor's analysis and notes and feelings about that, which were then shared with Dr. Kleiman. I understand Dr. Kleiman may not have kept anything of his own, but do those other things still exist? And what's your introduction of those?
No, I do not believe they do, Your Honor. And the position is exactly the same with respect to Dr. Celine Saulnier. And I hope I'm pronouncing her name correctly, actually. The response with respect to those is exactly the same with respect to Dr. Klin. They work in tandem, extremely closely, and have worked together for a long time. With respect to the actual assessments that involve questionnaires, my understanding of the procedure is that and the exploration of this, and if I were cross-examine the expert, it would simply be, I have the questionnaire. It's not as though Mr. Brenner cannot get the actual forms that were used with respect to it. And he can ask questions about the very specifics. But Drs. Klin and Saulnier do not keep the results of those. And again, there is strong temptation on my part to go into the why, but I don't think that's for me to attest to. I think on Tuesday, Mr. Brenner will know exactly what was done, how it was done, and that will be very insightful, very helpful for Mr. Brenner. But the argument that is essentially being made that any expert can prepare information and because draft reports are not kept or methodologies that's used for notes are not kept, somehow the expert is like getting away with an opinion. Doesn't make any sense. An opinion has to be substantiated. It has to be something that, in fact, an expert can support. And without even cross-examining Dr. Klin, to suggest that, to just summarily reach the conclusion that because the draft reports are not available, that somehow everything that he's put in his 17-page report, with the experience that a doctor like this has in autism, somehow renders that report indefensible, I don't think is a fair conclusion to make.
Thank you. All right, Donna. Maybe I heard only briefly.
Just because I want to make sure I'd like to be heard just very briefly, maybe 3 minutes.
Yes, Your Honor.
I'm sorry. Yeah. So, Judge, just again, I've made my arguments, Mr. McGovern's made her arguments. There's no dispute here about what the law holds. Okay? Which is really the only thing. Yes, you're supposed to listen to lawyer arguments and maybe it persuade you. But the law is what the law is. And this argument has been trotted out before. This is not novel, which is everything the expert relied on. And by the way, this living document thing is not from Dr. Kleiman. I don't see that in the report. But it doesn't matter. And I don't care what Dr. Kleiman does in his practice. I care what Dr. Kleiman when he's participating in a case where he's subject to Rule 26 disclosures. And the law is, as I cited you, and they have not given you a law before today, or today, if it's anything different. The data he relies upon, which is the interviews, which he took, I assume, copious notes on, and Dr. Salniak took copious notes on, because they had to share with each other, and the assessment they run, which we have cases directly for, they're just not draft reports. And my suspicion is that my colleagues, when they got my email asking for the stuff, they reached out to the doctor and learned that the doctor didn't have any, and that's a problem. That they perceive a problem, and that's where we got this draft report argument. I don't blame them for making it illegal, but I don't know what else they're supposed to do at this point. But the fact that he doesn't have them, Judge, it's not like, well, then we need to excuse it because he threw them away. That's not what the law is. The law is are these draft reports, and the answer is they're not. They're not under any, there's no case law that will tell you they are. None cited by the defendant, and I've looked for a lot for the last couple of days. And they just have to be something, they're safe for production, and if they can't produce them, then we'll examine why that happened, and the chips will fall where they may. I don't know where the chips will fall. Maybe there'll be no chips, but all that's before you today is whether they are draft reports, and they are not draft reports.
Thank you very much, Mr. Brown. All right, so let me first start out by talking about what I'm not ruling out, okay? Because these issues, these topics have kind of floated up and down in this hearing, and I want to make very clear on the record what I'm not ruling on. Okay, I'm not ruling on any issue relating to the timeliness of the expert reports or expert disclosures. No one has raised that. I'm not ruling on whether anything's done on time, not on time. No position on that. I am not ruling on any of the Dauber issues that may apply to this expert, including methodology, relevance, or other issues relating to admissibility. That will be for Judge Bloom to resolve as the trial judge, unless she refers it to me, but that's not before me today, and I'm not ruling on that. That has not been briefed, that is not raised. Also, I'm making no finding regarding a concept of spoliation, failure to preserve, anything like that. If that issue comes before me, I'll rule on it. It's not before me today, and if things used to exist and don't exist anymore, there may be all kinds of reasons there's no remedy for that. And that's fine. We'll deal with that if and when that comes up. So any findings I make today are not to be interpreted as having any view on timeliness, Dauber, relevance, admissibility, methodology, or spoliation. So that's my first comment. Second thing is, I tell you, I found the doctor's report to be very interesting. I think it raises a very interesting topic, very interesting. It's a very thorough report in that regard. But I do find that the cases cited by the plaintiff are persuasive here, and that there are not draft reports, at least that I'm satisfied have been shown to exist here. So I understand what happens. The first doctor meets with Dr. Wright, administers some testing, there's some analysis, there's some analytics done by that doctor. That doctor may take some notes, may write up some notes, meets with the second doctor. They confer, they may share their notes, they may share their findings, they may make joint notes. Ultimately, the second doctor writes a report, and that report is the final report that is then sent out to the other side. This is a methodology with which I am actually very familiar because it is exactly the methodology that I use when I write orders. I get pleadings from lawyers. They raise a legal issue. I say to my law clerks, read the briefs, do some research, then let's talk about it. And they do, and I do. We read the briefs, we make notes on the briefs, we do research, we print cases out, we take notes, and we talk. And we can talk about how the legal issues might be resolved. And then ultimately, after all of that conversation and all of that analysis and that whole methodology plays its way out, then we put pen to paper and we draft an order. And there may be some revisions to that. That would certainly be a draft. But that's not what I'm hearing is the issue with Dr. Kill. It's not that he did a draft of what it was pretty close to what ultimately went out, and had to fix some typos, rearrange some paragraphs, maybe change an opinion here or there. That's not what I'm hearing. So I'm very comfortable with this, understanding how this process would work, and in my view, that process simply does not result in the taking of notes by these doctors, the conversation between them, the analysis of the underlying raw data is simply not a report, in my view. And I agree with Mr. Brenner, it doesn't fall within the draft report exception to Rule 26. So I would order it to be produced. Now, if it doesn't exist, it doesn't exist, and that'll be that. But if it exists, I order it to be produced. What's the doctor's deposition, Mr. Brenner?
Tuesday. So my only request, if Ms. McGovern, either on this record or wants to double check, send me something tonight and says they don't exist, I can go forward on Tuesday. If they exist, I would obviously need them by the latest tomorrow to go forward on Tuesday. But if they don't exist, I'm going to delay the deposition because I'm not delaying it.
I want to make Ms. McGovern making representations on the record at this time, and I have to double check with the people she's checked with. If there are things to be produced, I would order them to be produced. Let's see. I know, Mr. Freeman, you have issues on Saturdays. Mr. Brenner, Ms. McGovern, are there going to be any issues with it being a Saturday if I require work to be done this evening or tomorrow?
Not for me, Your Honor.
Not for me either, Judge.
Okay. Then if there is something to be produced, I would order it to be produced by 2 o'clock tomorrow to Mr. Brenner. And if there's nothing to be produced, Ms. McGovern, as you have throughout these proceedings, you will do the professional thing, and you'll just let Mr. Brenner know that. So I have no problem.
Of course.
No problem. First of all, let me also say, extremely well argued today, counsel. Your argument was very helpful. The briefing was helpful. It's a fascinating issue. But that'll be my ruling for today. And again, the defense, I will note that Dr. Wright objects to that ruling. That objection will be preserved in the record, and if he wants to seek any review of my ruling, he may do so. With that, let me turn then to Mr. Brenner. Have I now at least addressed every issue you wanted to raise today, not waiving any objections you may have to the rulings that I've made?
Yes, Your Honor.
And Ms. McGovern, without waiving any objections you may have I at least addressed all the issues that you wanted to raise this afternoon?
Yes, Your Honor.
All right. Are there any other issues, as long as we're together, anything else that we should take up that we can help to facilitate moving the case forward at this time? Mr. Brenner?
I don't think so. I think we both have a busy 2 weeks ahead of us, and we're all working pretty hard to get it done.
I know you all are. All right, then I'll let you go. Have a good weekend, everybody. Wash your hands, stay safe, and we'll be in recess on this matter.
Thank you.
Bye-bye.
Conference recording has stopped.